If you ever wanted proof that the war between Prince Harry and the British press never truly ended, only changed battlegrounds, look no further than the High Court. Because while the headlines may come and go, the courtroom has become the latest theater in a conflict that has shadowed Harry for most of his adult life. And this time, the spotlight has shifted to the royal editor of the Daily Mail, Rebecca English. Now let's be clear about the stakes. This isn't gossip page drama. This is a serious legal confrontation involving allegations of unlawful information gathering against Associated Newspapers Limited, the publisher of the Daily Mail. The claimants include not only Prince Harry, but also Elton John and Doreen Lawrence. These are not casual names tossed into a filing. They are high-profile figures alleging grave breaches of privacy. And the newspaper, for its part, categorically denies those accusations. At the center of this particular moment in the trial are emails between Rebecca English and a freelance journalist based in South Africa named Mike Baer, referred to in court as someone who had sold stories to British papers for years. Harry's legal team alleges that Baer obtained private flight details about Harry's travels, particularly during the years when he was dating Chelsy Davy. The suggestion is that confidential airline information may have been accessed or persuaded out of companies who had no business sharing it. Now, if that allegation proves true, it is serious, deeply serious. But Rebecca English stood in court and denied ever asking for such details or knowingly using them in her reporting. She was unequivocal. She said she did not request flight information and did not rely on illicit sources. One article under scrutiny was a 2007 story describing what was called a make-or-break holiday between Harry and Chelsy. According to English, the timing of that trip was not derived from secret airline data, but from university contacts at Leeds, where Chelsy was studying. A contact allegedly told her that as soon as term ended, Chelsy would be traveling. From there, she says, journalists pieced together the likely scenario. Harry's barrister, David Sherburne, pushed back sharply. He pointed out that the article did not merely speculate, it stated with confidence that Chelsy was flying that weekend. According to Sherburne, that level of precision suggested access to flight bookings, something far more concrete than campus chatter. English responded that she did not recall receiving any such email detailing bookings. In fact, she described her professional relationship with the freelancer as strained. At one point, she told the court she had experienced not very pleasant behavior from him, and broadened the point to reflect on the lived experience of women navigating difficult male colleagues in competitive newsrooms. It was a moment that shifted the temperature in the courtroom. Suddenly, this wasn't just about flights and files, it was about power dynamics within journalism itself. Another article from 2004, titled How Harry Fell in Love, came under the microscope. It described Harry speaking about his girlfriend during a campfire gathering in Botswana. English testified that the information came via a colleague who received a tip from someone present at that gathering. According to her statement, Harry had spoken affectionately but not named Chelsy. Only later, when the relationship became public, did the anecdote gain significance. Harry, however, has expressed deep skepticism that anyone present would have spoken to journalists. He suggested the information could have been obtained through other means, potentially private communications. And that divergence, that fundamental clash of explanation, lies at the heart of this entire case. Was this normal reporting, the messy but legal business of tips, contacts, and piecing together information? Or did lines blur into unlawful territory? The court was also shown emails discussing Harry's movements around the Walking with the Wounded charity trek, including travel to Cape Town and his return to London for Christmas. Sherburne argued that this again pointed to confidential flight data being shared. English maintained that the charity itself had provided travel details directly to the press. And here we arrive at the deeper layer of this saga. Harry's battle with the British tabloid press did not begin in a courtroom. It began in adolescence. It was forged in flashbulbs, headlines, and the memory of a mother relentlessly pursued. For him, this legal fight is not abstract. It is personal. It is generational. But journalism, too, defends its ground fiercely. Newsrooms argue that cultivating sources and verifying movement is part of the craft. The line between persistence and intrusion can sometimes appear thin, but in law, thin lines matter enormously. As we watch this unfold here on The Crown Talk UK, what fascinates me most is not just who wins or loses, but what emerges. Trials like this peel back the curtain on how stories are built, how information travels, how reputations are shaped. If you value thoughtful, balanced royal analysis, do take a moment to like and subscribe, because this case is far from over, and its implications stretch well beyond one prince and one newspaper. In the end, this isn't simply about flight details or old romances. It's about trust between public